Looks like counsel is ready. I'll do one more check to make sure Justice Oxley's there still.
I'm still here. Thank
Okay,
you.
thank you. Our next case is American Home Insurance versus Liberty Mutual Fire Insurance. Mr. Oliver, you may begin. And just do a real quick sound check if you would.
Sound check.
Good afternoon, counsel. Thank you.
Thanks. May it please the court, your honors, counsel. I represent American Home Assurance in this action between two insurance companies under the provision of Iowa Code Section 8521, which is a statute that's been around for a while and provides a mechanism to work out payment disputes between insurance carriers. One of the goals is to help facilitate payments to claimants if there are disputes between carriers. Say the typical situation is when you have an employer that changes insurance coverage, and so then you have different dates of injury could invoke different insurance carriers. In this case, we're asking this court to reverse the Court of Appeals because we believe that there's a couple of errors committed by the Court of Appeals in one, interpreting 8521, and two, in misapplying agency law. First of all, on what we're seeking is something that will help clarify and establish guidelines and parameters for the agency to follow in future cases like these. 8521 1 refers to a contested case, and it refers to an evidentiary hearing. In the Court of Appeals ruling, the court continually referred to the claimant's arbitration hearing as the evidentiary hearing. But that language is not in the statute. And so it's our position that the court has misinterpreted, the Court of Appeals has misinterpreted the statute by arbitrarily limiting it to the claimant's arbitration proceeding rather than what the statute says. It broadly mentions a contested case and it mentions an evidentiary hearing.
Do we owe the agency's interpretation of this statute that it administers?
Well, I think it's limited deference because it's a review for errors at law. And so I think.
Question I have. I mean, we're not really interpreting we're not saying that some term in the statute means X or means Y. What we're really talking about is the agency's ability to enact sort of procedural requirements. I mean, every agency has kind of procedural rules about contested cases. You want to raise this, you file this, you do that, and they're allowed to enforce those procedural rules, it seems to me, unless they're at odds with the statute. And I don't see anything here that's at odds with the statute. It isn't interpretation. I think it's what we would call implementing the law. Am I missing something there?
That's kind of the second component of what we believe the Court of Appeals erred in and what the agency law is on this issue. It's mentioned in both briefs. There's something called the Van Wijngaarden rule. And the problem is that the Court of Appeals referred to the Van Wijngaarden rule as saying that, okay, so in an 8521 action, the law is clear that for an insurance carrier to get reimbursed by a different one, they've got to file a thing to get a 8521 order. It's just a form. Once it's filed, the agency grants it and says, okay, you're now able to file a petition for contribution or reimbursement.
That's a rule, right? An agency rule, and they have a form that they've adopted, and okay.
Created since that. So the question then goes to there is, once you have that order and you're asking another carrier for reimbursement, it's undisputed that you can get reimbursement for any benefits paid after the issuance of that order. Liberty Mutual doesn't even contest that. Once the order's entered, the carrier's unhooked. The question in this case is can you get reimbursement for benefits that were paid before the 8521 order? And the Court of Appeals suggests that under Van Wingarden, you cannot get retroactive reimbursement, just prospective reimbursement. The problem is, and I think why this court needs to clarify that, is that's not what Van Wingarden actually says. In the Van Wingarden decision, it says, where a petitioner for reimbursement has sought an order pursuant to Iowa Code 8521 prior to the evidentiary hearing, reimbursement may include payments both before and after the order was issued. So,
Paula Areola case, this seems to be the most recent decision of the commissioner on this point. Doesn't that seem to say you have to get the reimbursement order in place at the time of the hearing, or else you're limited to prospective relief?
well, again, what's happened since Van Wingarden is that there's been cases in the agency that have gone back and forth, and by using the word hearing, they're conflating it with the arbitration hearing, not an actual hearing that could be held between two.
Saying in their most recent line of cases, they're misinterpreting the law, is what you're saying. But what in the statute prohibits that interpretation? I agree, I don't see anything in the statute that particularly commands it or requires it, but what in 8521 prohibits that approach?
Because, like, for example, one of the decisions we cited, this Andover versus Travelers, there was a separate 8521 action. The claimant wasn't even involved in that case. There wasn't even an arbitration proceeding. And so if you're limiting it to the arbitration proceeding, you're defeating the purpose of 8521, because a lot of these 8521 actions, the claimant has either settled or is taken care of, and then you have a separate evidentiary hearing involving the insurance carriers.
What in 8521 itself says, I can see the policy argument for requiring this to be resolved at the time you have the evidentiary hearing. Obviously, and I assume that American Home would have done that if they'd been aware that Liberty Mutual was actually the carrier for that period of time. They would have brought them in and gotten it resolved at the hearing. It was an oversight. But it seems to me there's a policy reason to get it resolved all at once, so you're not coming back after the fact, and so that Liberty Mutual has a fair opportunity to appear and be heard and defend the compensation claim if they want to. So what in 8521 forbids the approach that the commissioner is following these days?
The bottom line is, I think, the use of the word evidentiary hearing, because in this case, Liberty Mutual couldn't have been involved in claimant's underlying proceeding because no one knew that the deputy was going to pick an injury date that wasn't even pled by claimant, and that happens sometimes. So then liability 8521.3, it says when liability is finally determined. In that case, or in our case, liability was not determined, the date of injury was not chosen until the deputy issued the decision.
This client still made a mistake. There was a possible injury date of 2018 that was always in play, and that would have been Liberty Mutual's coverage in any event, right?
The deputy ended up picking one in 2018 within a month or so of that. That is correct.
About the 3-year bar in subsection 3.
Okay. That sort of became a big issue in the Court of Appeals decision. Now, the court didn't ultimately decide anything on that, other than they said that there is no time bar because the case or all claims were kept alive because claimant filed a review reopening within 3 years of the date of the last payment by American Home Assurance. So we're not up here today saying that there's no statute of limitations for filing at 8521. Say you had a mistake that was found out 25 years down the road. I think under the language of 8521.3, there still has to be an action within 3 years of the date of the last payment that keeps claims alive.
Reopened this, would that 3-year period have passed?
If the claimant had never filed a review reopening, this case would have likely never happened. Even if my clients found out whenever they did, 5, 6 years later on down the road that, or whatever it was, that the mistake was made and there was no action pending, then I don't think there was any legal remedy under 8521.
Is the 3-year bar in 8521.3 relates to this claim for contribution from the other carrier, right? I guess, to some extent, would that suggest that the agency's rule is contrary to the statute? I mean, it seems like the statute contemplates that after the arbitration decision involving the claimant, there's still a 3-year window for a carrier to file one of these types of claims.
That's part of the world we live in work comp in the sense that, and this one's a little bit different because it's under 8521, it's between two insurance carriers usually. But the legislature did put a 3-year limit in 8521, and the analogous thing is that we see most often is there's no limit to review reopening petitions. A claimant can file.
Here's my problem with this 3-year thing. It says, a party shall not be maintained against a party to a case or dispute resulting in an order authorized by this section. All right, so Liberty Mutual was not a party to the original dispute or case resulting in an order. They didn't even know about it, right? Okay, so they're not a party. So that couldn't apply here to them. It almost sounds to me like this is a limit on what kind of an action you can maintain on the original or on an order you already have in effect, not a limitation on your ability to go out and get a new order, which is what you were talking about. It deals with a separate issue, doesn't it?
We're dealing with one 8521 order. There's just the one order that's entered, and once that was entered, then we were leading down a path to a separate evidentiary hearing with Liberty Mutual that would have satisfied 8521.1. The only reason there wasn't another evidentiary hearing on this matter is because of the summary judgment rulings that were issued within the agency. So
Mutual going to get a windfall here?
yeah, about 240 grand. And so that's I think that's why mistake law in the Wilson versus Cherry case it's not directly on point, but it's a work comp case that talks about, in general, if there's mistakes made, it should be corrected. And many of the agency decisions which we cite in our briefs indicate that the insurance carrier that's on the hook for the date of injury should be required to pay the benefits for that date of injury. And yes, it's a fair point. Why didn't my clients figure out the mistake sooner than it did? But they did, and we believe that there's a mechanism under the law to make sure that Liberty Mutual is required to pay the benefits that the agency awarded. So, kind of in conclusion, I think what we're asking this court to do is, and this would correct what we believe the two errors in the Court of Appeals decision, is one, to make it clear that an evidentiary hearing is not limited to a claimant's arbitration proceeding, to also make it clear that once an 8521 order is imposed, it can involve reimbursement for benefits paid prior to or after the 8521 order. And then just generally, to say that a contested case is not limited to a claimant's arbitration proceeding, that it includes actions between insurance carriers, which is what this is about. So unless there's no further questions, I'll sit down.
May it please the court, counsel, Ben Erickson from Grief and Sydney Law Firm on behalf of Liberty Mutual Insurance Company. I want to start off by an issue that was raised as to what standard of review applies to the Supreme Court in this case. And I think it's important to note from the outset that the Supreme Court, this court, has already considered the issue as to what standard of review 8521 applies to. And in Second Injury Fund of Iowa versus Bergeson, which can be found at volume 526, Northwest Reporter, second edition, starting at page 543, this court applied the deferential standard, meaning that the standard would be reviewing it based on an irrational, illogical, or wholly unjustifiable conclusion that the commission level made, which is ultimately what the Court of Appeals decided as to what the review standard would be. Taking that as our initial basis, I think it's clear that, as Justice Mansfield pointed out, the commission has said that you can't seek reimbursement under 8521 if you seek reimbursement after the evidentiary hearing on the underlying claimant's injury case, which in this case is what American Home Assurance did. I think that that's clear. The Iowa Court of Appeals in their decision does a good job of articulating all of the commission decisions in which, cases that have held as such.
Contingent on the standard of review? Or do you think that's a correct interpretation of the statute and the rule?
Correct interpretation of the standard review. And I think that that's something that was brought up during I think you had actually asked the questions, Justice McDonald, with regard to the 3-year period. I think Justice Mansfield was correct. When you look at the 3-year period limitation in Section 3, it talks about contested case is commenced within 3 years from the date of last benefit payment under the order. And the question is, what order? And I would just present to the court that the order that we're contemplating is what's contemplated in Section 1, meaning that when there's a dispute among insurance carriers, we're not going to hold the claimant hostage and not allow them to get benefits. If they can't agree, the commission has the authority to order one of the parties to make that payment, so the claimant can get prompt payment, which is kind of the underlying purpose of the workers' compensation system. After the evidentiary hearing, that's when the court has the authority under Section 3 to make the order as to who's liable for the payments that have been made to the claimant. So just to summarize, I think
On that language in subsection 3, it says, maintained against a party to a case or dispute resulting in an order. So case or dispute, what does dispute mean here?
I think when you step back and look at the forest through the trees of 8521, when you're looking at Section 1, Section 1 doesn't apply to the commission's ability to order certain carriers to reimburse other insurance carriers. It specifically deals with entering an order as to which defendant, which insurance carrier, which employer is going to initially pay benefits. Then you jump down to Section 3, which is dealing with the commission's ability to order reimbursement on that. So I think the entire premise, meaning what is an order, I think that the order is contemplated in Section 1, meaning the initial order to make payments, which I think if you accept the district court's interpretation of this whole evidentiary hearing, it's not that narrow, it's broader than that, then I think it gets rid of and makes that line that we've been talking about, this 3-year limitation, it makes it irrelevant.
Your argument is that the Court of Appeals got it wrong, and that when it was reopened, that doesn't restart any clock. Do I have that right?
I understand the question.
Opposing counsel said that this 3 years would have run, but for the restart of this case, right? The request for more benefits. And so your argument is that that doesn't matter, that it goes from the order that was entered in whenever it was 2011 or 2012, and not from the restart of this case.
I think if you accept American Home's assurances ask as to the interpretation of 8521, I think that 3-year limitation becomes irrelevant. Not only does this, review reopening save that, I think arguably that, like I say, that 3 years from the date of last benefit payment under the order, I mean, what an order is just simply a rubber stamp. So meaning they could have filed at any time, gotten an order, and then subsequently filed a contested case allowing them to seek the benefits from Liberty Mutual. I think that, that order specifically has to be tied into Section 1, meaning that if there is no order, I don't think that the 3-year limitation period has any meaning whatsoever. And I think from an interpretation standpoint, I don't think that the court, is in a position to ignore that language.
Saying that, then I want to make sure I understand. Are you saying then that as regards the initial order, the 3 years ran, AIG is done. I can't pursue Liberty Mutual anymore. And if they want to get a new review, if the claimant brings a new review reopening, then that would be another order, and they could seek to have Liberty Mutual ordered to pay the benefits for that. Is that your position?
It's not my position. My position is that there's an either or with regard to the 3-year period, meaning that you either have to accept American Home's ask as to how you interpret this under the order language at the end of Section 3, meaning that an order is simply the rubber stamp saying that, we're going to look at this and we're going to make an order as to, Liberty got this windfall 3+ years ago, so we're going to order you to make this payment. Whereas Liberty Mutual's ask as to what that interpretation should be is the order contemplated in Section 1. And what Section 1 contemplates is, like I said before, a situation where, two insurance carriers, two defendants are disputing as to what the...
What had to have happened is AIG made sure your client was part of that initial proceeding, and then later on during the 3 years, they could have come back and fought over whether you or they really owed the money. Okay.
This may be the exact same question, but I want to make sure I understand this. So procedurally, how this would work is at some point prior to the arbitration hearing and then decision, there should have been an 8521 order requested. As I understand it, it's a rubber stamp, and it's just a request by the carrier that we may be on notice that there's a dispute about who pays benefits. Once that's issued, they have 3 years under 8521.3 to actually bring a case to get that dispute resolved from the last date of the payment of the benefits. Correct. And if they don't do that, then they're just barred. If they don't get the 8521 order, then they're just barred from filing this later action. Is that so? In this case, though, the bar doesn't apply because there was review reopening, right? Correct. So does all of that procedural stuff necessarily answer the question about whether the relief can be prospective or retrospective? So what in the statute or in the rule says, well, once they have a timely petition and you have the 8521 order that in this case was rescued because of the review reopening procedure, why can't they go backwards and get all of the prior benefits?
I think, well, number one, I think it's inconsistent with prior commission rulings, meaning that they've made the determination that if you don't get an 8521 order before the evidentiary hearing for the underlying work injury case, the arbitration hearing, then you can't seek reimbursement under 8521, which is what the commission ruling is. On top of that, Section 1, I'm sorry for repeating myself, but yeah.
Agency rule implementing the statute, if it's consistent with the statute, or at least it's not explicitly prohibited by the statute. Okay.
Statute, and I think that to interpret it a different way, I think leaves aspects of the actual code section 8521, makes them arguably irrelevant.
So what would happen in the situation, it sounds like maybe almost happened here, if at that hearing a different injury date is found? And so there wouldn't have been any opportunity to bring in another carrier. Are they out of luck?
Well, I think, I appreciate that American Home has brought that up, and I think that argument's a little bit of a red herring in that when you're looking at a cumulative injury, it's an objective standard, meaning you're looking at when the injury manifests itself. And what this court has said is that the date on which both the fact of the injury and the causal relationship of the injury to the claimant's employment would have become plainly apparent to a reasonable person. Part of the reasoning for interpreting 8521 the way that the commission has interpreted it is that it does give a party like American Home Assurance the opportunity to, conduct discovery, conduct depositions, do what they need to do to prepare for the case, to ascertain when that manifestation date might be.
Experience in this area, is it common or uncommon for carriers to identify potential other carriers when they know the date of injury may be around a window where coverage ends and another carrier's coverage begins? So in this case, at least they were on some sort of notice that the injury date could fall on another carrier. So is that common, where it's in the gray zone, that one carrier would name another just to cover its bases, or is that an uncommon practice?
I think that the commission rule as to how it's set up, and if the court would rule consistent with the commission's interpretation today, I think to your point, it would become more common because it would put insurance companies on notice that if there is a chance that this potential injury date is going to fall outside, then you need to bring this other insurance carrier in or this other defendant in as a potential party or seek a notice from the commission. And what I think that does is it gives a party like Liberty Mutual, who in this case didn't have an opportunity to participate in the hearing, didn't have an opportunity to conduct its own discovery, an opportunity to do that. And to be involved in the settlement discussions and try to resolve the case before going to an arbitration hearing. One of the notes that the commission has made in some of these rulings is that, had this case not gone to hearing, American Home could have settled the case and Liberty Mutual would have had no input in what dollar figure they came to in the settlement. So I think that a ruling consistent with the commission is going to go a long way in giving a party like Liberty Mutual in Liberty Mutual's position an opportunity to have a fair opportunity to defend the case at the evidentiary hearing.
Opposing counsel referred to it as a windfall. Would you call, and you used that word too, would you call this a windfall for your client?
I think it's yes. I mean, it's undisputed that this is a situation that American Home Assurance insurance had ended and Liberty's had started. So from a technical term, Liberty Mutual was the party that should have made the payments, pursuant to the insurance contract. That being said, I guess, circling back, I think that there's a lot of policy reasons behind how the commission has ruled on 8521 because, yes, you call it a windfall that Liberty Mutual got, but, this court has considered due process issues with regard to, defendants in work comp cases being able to know if an injury is a cumulative injury or not. I think that, ruling inconsistent with the commission arguably cuts into that, meaning it doesn't give Liberty Mutual the due process ability, again, to conduct their own discovery, enter into settlement discussions, and defend at the evidentiary hearing.
The commission's approach makes sense. You want any potentially involved carrier to be involved early so they can make their own decisions and not miss the opportunity to settle or do some discovery that might make a difference.
I see that I'm out of time.
Just a couple of quick things. I think the discussion and the questions, especially by Justice McDermott and Justice McDonald, kind of show the legal gymnastics we have to jump through to try to interpret the statute to limit an evidentiary hearing to the claimant's arbitration proceeding only, when that's not what the statute says. To do that, you have to try to figure out, are there other possible insurance carriers? How do we get everybody involved? And from a practice standpoint, I've been practicing over 20 years, and that never happens. The only insurance carriers that...
Limitations period under your view, that's the concern. I mean, you said it's not 25 years. What is it?
As long as there's an active review reopening proceeding, it would be that 3 years. But the 3 years is can be a changing thing. So in this case, the last indemnity payment was made by my clients in 2013 sometime. Claimant filed review reopening within that 3-year time period in 2016. And then because there was an active litigation proceeding at that time, my clients found out the mistake and they issued, they got the 8521 order in early January, I think, of 2017. So the
And I guess maybe I'm repeating ground that my colleagues have covered slow, but what you're saying is that if there hadn't been a review reopening, you concede that your client would have been too late?
Correct.
Opposing counsel's argument that, and it seems to make some sense to me, that you want one carrier to give notice to another under 8521 that these benefit payments may be disputed, and if you don't do that, then the second carrier doesn't have an opportunity to defend or settle the claim, and they may be on the hook for whatever your client did. And I'm not saying your client botched the case or got a suboptimal result, but it's possible. So what about that? That seems to make sense to me, that you would want all the parties at the table prior to the arbitration decision.
I mean, I can say from practice perspective is, I've had other situations where you have the deputy picks a different injury date or awards something else that nobody was planning, and so then that automatically invokes a different carrier that nobody was planning on. And
in this case, it's, at least according to the Court of Appeals, the claimant amended their petition and alleged a June 2018 injury date. So shouldn't have that kind of raised a red flag? At least AIG should have looked and said, gosh, we don't provide coverage to this employer for that period of time.
I mean, hindsight, yes. But there was at the time that case went to hearing, there was 2 injury dates pled. The first one was admitted by my clients, and the second one was denied. And the second one was the one that was in a different, like in 2018, a different month or something. And so, that's why I think the statute is helpful to show that there can be multiple contested cases, multiple disputes, multiple evidentiary hearings to sort out these payment disputes. And The last thing I just wanted to mention, counsel brought up the Bergeson decision by the Supreme Court. And the last sentence of Bergeson says, Section 8521 gives the commissioner authority to order reimbursement where one party makes voluntary payment that ultimately the commissioner determines should have been paid by another party. And so I think that stands for the proposition that the agency has broad authority to make sure that however it shakes out with what's awarded by the deputy to claim it, the insurance carrier on the hook is responsible for those benefits. Thank you.
Insurance versus Liberty Mutual Fire Insurance is hereby submitted, and court is adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.
Exactly.